Hello friends, in my YouTube channel Advocate Amit Kumar Gupta. Today we will discuss the very famous case of Supreme Court which has been recently decided. The name of the case is Principal Commissioner of Income Tax versus KHYATI Realtors Private Limited. This judgment is reported in 447 ITR at page number 167 and the matter has been decided on 25th August 2022. The facts of the case are like this. The assessee is in the business of real estate and some financing business. The assessee advanced an amount of rupees 10 crore to another company for purchasing some commercial place. This advance was given in 2007 and this amount was written off in 2009 in a very short span of two years. The point of the assessee was that the company to whom the advance was given was not able to fulfill its commitment. The assessee made its attempt to recover the amount. Because it was not able to recover the amount, so this amount was written off. But the Supreme Court analyzed in this case that there was no clear-cut proof in the documentation of the assessee that this amount has been actually written off. And for writing of the bad debt, under section 36 subsection 1 clause 7, it is essential that it should be taken as income in the previous year. It is but natural. Until and unless you have shown the amount which you are going to claim as bad debt in the previous years as income, then how you can claim this amount as bad debt in the current year? Under section 36 subsection 1 clause 7, the Supreme Court said that until and unless an amount is a debt, that amount cannot be turned into bad debt. The assessee first time at the level of the ITAT said that if you are not giving my claim under section 36 subsection 1 clause 7, because it may happen that the assessee has realized that I am not going to get this claim under section 36 subsection 1 clause 7, then I can get this claim under section 37 subsection 1. Because the assessee was saying that this is my business of financing, I have advanced this loan and this amount is not recoverable. So the benefit of section 37 subsection 1 should be given. The court said that there is no denying the fact that if any amount which is for the purpose of the business and which cannot be claimed under section 30 to 36, that can be claimed under section 37 subsection 1. But an amount which cannot be claimed as bad debt because of the explanation of section 36 subsection 1 clause 7, that amount cannot be claimed under section 37 subsection 1. Because the explanation to section 36 subsection 1 clause 7 says that the amount cannot be claimed as bad debt when the amount is credited to the provision for bad debt and the amount and at the same time that amount is being shown as a deduction from the debtor's figure in the balance sheet. The assessee was not able to give the evidence that whether this amount was actually written off into the books of accounts. And as far as section 37 subsection 1, in which the assessee was saying that I have given this loan, the Supreme Court said that there is no loan agreement, you have not charged the interest. It looks like a cooked up story. So the Supreme Court said that the decision of the ITAT and the High Court was not justified. So the Supreme Court reversed the judgment of the ITAT and High Court who has given the relief to the assessee. In this particular case, the facts of the case were not appreciated properly by the ITAT because the books of the assessee, the evidence on record was not showing that the amount was actually written off. The assessee was not eligible to claim it as a bad debt under section 36 subsection 1 clause 7 because this was not shown as income in the previous years. And as far as section 37 subsection 1 was concerned, the assessee was not able to provide the documents that the interest has been received on this loan. There was no loan agreement. There was no proper correspondence. Only the assessee was saying that there were some meetings with the directors of the company. There was not a strict action taken by the company for the recovery. The proof was not brought on record that the company who is not paying the amount, what actually that company has given the treatment in its books of accounts. So as far as the evidence is concerned, in this particular case, the Supreme Court has not laid down any law that you cannot give any, you cannot claim any deduction for any loan given, or when it is given for the purposes of the business. Because any amount which is given for the purposes of the business, if it is not recovered, then it can be claimed as bad debt. Then it can be claimed as an expenditure under section 37 subsection 1. But if it is not for the purposes of the business, and if it is for the capital expenditure, then there is a very weak chances of claiming it as a expenditure under section 37 subsection 1. So in this particular case, the evidence given by the assessee were not appropriate. There is no any strict law laid down by the Supreme Court in this case that if you have given any advance for the purposes of the business, that it cannot be claimed as an expenditure. It is not so in this particular case. The facts of the case are very interesting. One should go through the whole judgment. Even then, one can know the integrity of the judgment of this case. At the end of this video, once again, I am repeating the name of the case. The name of the case is Principal Commissioner of Income Tax versus KHYATI Realtors Private Limited. Thank you, friends.